Today, we're tackling a subject of paramount importance for homeowners: your undeniable rights to surplus funds generated from a tax sale. Before we get started, make sure to like and subscribe for more content like this. Let's begin. It's a harsh reality that properties can be sold due to unpaid taxes, but it's equally important to understand that this doesn't mean you lose everything. There's often a silver lining in the form of tax sale overages, and knowing your rights is the first step to reclaiming what's rightfully yours. Let's be clear. The right to surplus funds from a tax sale is not a mere courtesy. It's a constitutionally protected property interest. The Fifth Amendment to the U.S. Constitution, applied to the states through the 14th Amendment, dictates that private property shall not be taken for public use without just compensation. While a tax sale is a legitimate exercise of governmental power to collect delinquent taxes, it does not grant the government the right to profit from the sale of your property beyond what is owed. Numerous court decisions, including the landmark Tyler v. Hennepin County case, have reinforced the principle that any excess funds generated from a tax sale, beyond the tax debt and reasonable costs, must be returned to the former owner. If your home, which is valued at $200,000, is sold at a tax auction for $150,000 to cover a $10,000 tax bill, the remaining $140,000 is not the county's, it's not the buyer's, it's the previous homeowner. Identifying your entitlement to surplus funds. Primarily, the former record owner of the property at the time of the tax sale is entitled to the surplus funds. However, the scope of claimants can extend to family. If the former owner is deceased, their legal heirs may be entitled to the funds. Mortgage companies or lien holders. Parties holding valid mortgages or other liens against the property at the time of the sale may have a claim to the overages, often in order of their lien priority. Assignees. In some cases, the right to claim overages can be assigned to a third party, though this is a complex area with varying legal interpretations by state. It's crucial to understand that the government's obligation is to hold these funds in trust for the rightful owner. They are not simply absorbed into public coffers. One of the most significant challenges homeowners face is simply being aware that surplus funds exist. While taxing authorities are legally required to provide notice of the tax sale, the notification regarding surplus funds can be less direct or easily overlooked. Often, notices are sent to the last known address, which may no longer be current if the homeowner has moved due to the tax sale or other circumstances. Here's the problem. Official notices about surplus funds might be buried in complex legal jargon, sent to an outdated address, or simply get lost in the shuffle during a stressful period for the homeowner. The solution is to be proactive. Asking questions is key. If your property has been subject to a tax sale, immediately contact the county tax collector's office, the county clerk, or the office responsible for tax sales in your jurisdiction. Ask specifically about the existence of surplus funds and the process for claiming them. Don't rely solely on receiving a notice. Another problem homeowners may face is the statute of limitations on how long you have to claim tax sale overages. If you miss this window, your right to the funds may be forfeited. The solution is, as soon as you become aware of a potential overbid, investigate the specific laws in your state regarding the claim period. Some states have periods as short as 1 or 2 years, while others are more generous. Act swiftly to protect your claim. If you would like a free 50-state guide to surplus funds to see how to collect these funds in your state, check the links in the description. Thanks for watching.